thank you very much for your time and your energy to be here. I know you have a lot of work, sometimes because of us, but so let me quickly introduce you. Judge Grabinski, Dr. Klaus Grabinski is president of the Court of Appeal of the UPC and
Recording in progress.
And chairperson of the Presidium of the Unified Patent Court since November 2022. Before, he served on the German Federal Court of the Justice 10 civil decision that has inter alia jurisdiction on patent litigation matters, including as a deputy presiding justice of the division. Prior to joining the German Federal Court of Justice in 2009, he held a number of judicial roles, included as a presiding judge of the patent litigation division at the Düsseldorf Regional Court and as a judge at the Düsseldorf Higher Regional Court. He was an external legally qualified judge, externally legally qualified member of the enlarged Board of Appeal of the EPO. Judge Lignieres is currently a legally qualified judge at the UPC's Paris Local Division. She is the presiding judge of the Paris Local Division, and she's a member of the Presidium of the UPC. Camille Lignieres joined the judiciary in 1994, where she was in charge of civil, commercial, and enforcement law matters for more than 19 years. In 2013, she joined the Paris Court of First Instance in a chamber specializing in intellectual property law, with exclusive jurisdiction for patent law matters, where she shared as presiding judge of the panel. In 2019, she was appointed to the Paris Court of Appeal in the Economic Law Chamber in charge of competition and distribution law disputes. So I'm going to ask you some questions, and then at the end of the panel, the audience will have the opportunity to raise some questions as well. The first thing we're going to talk about is venue selection. We know that US patent law practitioner loves venue selection. So Judge Lignieres, how are the judges of the panel chosen? Is there a way to know and or influence the designation of judges?
Thank you for your question. Good afternoon to everybody. First of all, I would like to say that I'm really pleased to be with you today in DC. It reminds me of good memories when I used to live with my family in DC 20 years ago in Dupont Circle area, so close to your location there. And I was invited by the law department of George Washington University to give a presentation on the French judicial system during the lunch break of the professors at law and who had warmly welcomed me. So to come back to your question, how are the judges of the panel chosen? Concerning the first instance division, the panel of each division is composed of one or two local legal judges, and the president of the Court of First Instance allocates one international judge to the concerned panel for each case. So the chair of the panel is always a judge of the nationality of the country where the local division is located. So it ensures stability in this local division. But the panel is always multinational, which ensures harmonization of case law throughout the UPC. The international judge is chosen according to several criteria. The first is his ability to work in the language of the proceedings. You know that there are several official language before the UPC, and also according to his own workload in his own division. Finally, upon the judge rapporteur request, so the judge rapporteur is the judge in charge of the case management of the case. A technical judge is allocated to the panel, and the choice of this technical judge is made by the president of the Court of First Instance, taking into account first the expertise of this judge in the particular technical field according to the patent in suit. And second, the absence of any conflict of interest. That's the main principle when the president has to choose the members of the panel. So local judges, an international judge, and a technical judge.
Thank you. Judge Grabinski, how do you ensure uniformity and communication among the judges of the court?
Good afternoon, everyone. It's a pleasure joining you in Washington, D.C. Like Judge Lignieres, I love coming to Washington, D.C., but this time I only can join you virtually. I hope we still will have a wonderful afternoon. So, yes, how to ensure uniformity and communication among the judges of the court. This question has different aspects. Of course, I'm the president of the Court of Appeal of the UPC, and there are 13 local divisions. There's one regional division, so a division that is shared by a number of member states, and then there's the central division, and they all are form the court of first instance. But there's only one Court of Appeal, and the function of the Court of Appeal is clearly to ensure the uniform application of the law that is to be applied by the UPC. So it is primarily the Court of Appeal who decides on questions how to interpret the law, in particular also in situations when local or regional or central division may have different views on how to interpret the law. But this is just one aspect. There are more than this. The judges come from different European countries, but they are all now together, and they are supposed to not to apply their national law any longer, but the law that is applied by the UPC. And one way to make sure that this is going to happen is the international composition of the panels, like already explained by Judge Lignieres. The panels are composed of judges that coming from different contracting member states, and so they come together and have to decide the case on the uniform law that is to be applied by the UPC. So that is one way to have these international panels, and then the judges that are not from the panel or from the division where the case is decided, they go back to their own division, and then they share these views. They also, from time to time, meet virtually, discuss legal questions. That is called the Judge's Corner. So that's another way to make a uniform application of the law happen. And the court also organizes trainings for the judges where they meet, they discuss legal issues, they get informed about decisions from other divisions. And that brings me to another aspect that is important. That is, of course, our product. The product that comes out of a court are decisions and orders. And these decisions and orders are published on the UPC website. And we, as a court, we try to make sure it is not the case in each and every case, but with regard to the important decisions, that's true, that all the decisions are available in English, be it because the language of the proceedings is anyway English, but also in case the language of proceeding is another language than in English, then there is a translation available, so that all the judges, even if they speak different languages, at least by reading the decisions or the translations in English, become aware of what their colleagues in the other division decided.
Thank you. It's proof what we discussed this morning about the will of the court to provide predictability to the users of the court. We also discussed a lot this morning about injunction and damages, which can be sometimes a challenge to have in the US. So the UPC agreement provides for damages calculation. Judge Lignieres, how do you substantiate damages claim? Are there discovery proceedings? Is it large like in the US or narrow and limited to some specific documents?
Well, usually before the UPC courts, the damages are claimed in a separate procedure after the issuance of the decision on the merits or a final order concerning preliminary injunction. It is also possible for the parties to ask for an interim award at the stage of the first procedure, at the stage of the final decision. In fact, we have in the UPC rules of procedure the possibility to request to lay open books of the losing party, so the winning party can access documents relating to turnover and profits generated by the infringement. So before the UPC, no need for discovery proceedings. And to conclude, I would say that in a majority of our cases, parties find an agreement on the amount of damages after the decision on the merits when they know the outcome.
Thank you. Thank you very much. So we discussed this morning the difficulty for U.S. court to issue an injunction. So Judge Grabinski, what is your position on the injunction? Would you say that the UPC is willing to issue one, or that injunctions are an exception?
The principal idea that is taken in Europe is that patents, like other IP laws, are exclusive, give exclusive rights to their owners. And when this right, the court finds that this right has been infringed, and the court also finds that the patent is valid, so a revocation action was not successful. In that situation, it is one consequence also under the UPC agreement that an injunction may be granted. I'm aware that in the US, following the eBay decision of the Supreme Court, the landscape, which was more or less the situation like I mentioned for Europe, was more or less the same in the US, but since eBay it had changed. That is also part of the concept of common law and the concept of equity law, which is not as such known, at least not on the continent in Europe. In Europe, the concept that could be considered to be to some extent an equivalent to eBay is the principle of proportionality. However, there it has to be said that in principle, the party who invokes proportionality, so the defendant in infringement case, must give arguments why the issuance of an injunction is disproportionate. And we've seen this in practice not very often. And when it was noticed, it was not always or was rarely successful. There are some exceptional situations, of course, on which I do not want to touch in detail, but the situation that there is a friend license or a standard essential pattern and friend license is a very particular one. So I'm not touching upon this, but there, of course, we have the guidance from the Huawei CTE decision from the European Court of Justice.
Thank you. We also discussed this morning the possibility for of cost award from the losing party to the winning party. This cost award being capped by a tailing published online. So, Judge Lignieres, do you consider the cost recovery automatic, and should it be substantiated?
Well, the principle set in the UPC rule is that the losing party must reimburse the winning party for the cost it incurred in the proceedings. So it's a principle. And a provisional sum as an interim award is often awarded at the time of the decision on the merits or at the time of the final order for preliminary injunction. Sometimes parties agree on a reasonable amount regarding the case at hand. In most cases, representatives provide an invoice regarding their legal fees. This invoice is not really detailed, but we have the total of the legal fees in principle. And if this amount is reasonable and proportionate, the court will order the unsuccessful party to pay the fees incurred by the successful party in the case. So the party that won the case may, after the decision of the merits, return to the panel to request additional costs in separate proceedings after the decision on the merits or the final order for a PI. And an additional sum could be granted for the costs, but this amount is limited by a ceiling already known. It's set in an administrative decision and is set according to the value of the action. So the parties have an idea at the early beginning of the proceeding of the action about the amount of the legal fees incurred in the case.
Thank you. Judge Grabinski, what are the main features that seem essential to UPC proceedings according to you?
UPC proceedings have three phases. So it's the written procedure, it is followed by the interim procedure, and then by the oral procedure. And what is main characteristic is already the written procedure, which is very important because the parties are supposed to submit all facts, all evidence, all requests as early as possible in the proceedings. So it is not good enough to file a statement of claim with a few arguments and then later, or a few facts, and then later add on facts. Because when they are only introduced at a later point of time during the procedure, they may not be allowed to be considered in the procedure. So it is what is sometimes described as a front-loading procedure. This applies to the claimant, but also to the defendant. And that is one way or one important means to make sure that the procedure is, on average, will be finished in the first instance proceedings within 1 year time. That is, of course, appreciated, that proceedings don't take 2-3 years, but just 1 year on average. And one main way to do this is this really strict principle of written procedure, that all the facts, all the evidence have to submit it as early as possible. Second, a mean to make sure that the procedure on average is done very fast are the strict deadlines of the procedure. So the deadline for filing the statement of defense, once the statement of claim and infringement action has been brought, is as from the day of service of the statement of claim is 3 months. And by the same time, also, if a defendant in the infringement action likes to bring this, it's time to file a counterclaim for revocation. So it's a rather tough deadline, but as said, the idea is to streamline the procedure, so to get it done in a rather short period of time. Another feature, or maybe when I talk about the timelines, of course, when the case is extraordinarily complicated, then it is always possible to extend the timelines, but that really needs justification to extend the timelines. It is not just done for reasons like, okay, sorry, the end of the timeline is falls into my holidays, so that would not be accepted as a reason for extension. And one more characteristic is also the interim procedure, which has two aims. First of all, the judge, if there are some indications, may try to settle the case, or as of next year, mid of next year, there will be a mediation and arbitration center. So if there's an interest from the parties to try to get the case settled by arbitration or mediation, that would also be the right time to do this. So that is one part of the interim conference or procedure. But the second part is to prepare the oral hearing. So do all the necessary preparation for the oral hearing, and then the aim is to have the oral hearing done in 1 day. When it's very complicated, it can be 2 days, but normally that should be done in 1 day. And after the hearing, then it takes a few more weeks to issue the decision. But then you, in an average case, the parties have a court first instance decision. And I think so. The rapidity of the case of the procedure and the tools I described, these are, to my understanding, main features and essentialities of UPC procedure.
Thank you. Judge Lignieres, would the US nationality of a party impact the outcome of a decision?
First of all, I would like to draw your attention to the fact that already the US companies are often involved in the UPC cases. To give you an idea, in my division, in the Paris local division, in around 50% of our cases, the parties are US companies. And in 70% of these cases, the US companies are claimants in the infringement action. And so I see only two specific impacts of being a US party in a UPC case. First, concerning the language of the proceedings, and second, the security for costs to guarantee the legal fees. First, the language of the proceeding. In general, it will be English. except if the US party is involved as a defendant in a case where the patent is in German or in French, for example, but in general it will be English. Second, concerning the security costs, in the case of a request of security costs, there is now a consistent case law that tends to ask a party outside of the EU to make a deposit on the UPC account or a bank guarantee in an EU bank rather than in a US bank. It's always done without.
Thank you. Judge Grabinski, what are the main areas of improvement of the UPC?
Could you explain a bit the question? What is
the main areas of improvement? Where do you consider that the UPC could improve?
We could do better, you mean?
Yes, exactly.
Okay, good. Maybe there's one good news in this context. It's more of technical nature. The UPC introduced a new case management system just 1 month ago or 2 months ago that will help users to exceed the system in a good way. And you have to understand that the court is an e-court, and so that is a quite important aspect for the UPC. Yes, the main task that lies ahead for the UPC is clearly to develop a stable and reliable case law. And we are already working on this. A lot of decisions have already been issued, and you will see step by step the Court of Appeal will develop a case law regarding the essential questions of substantial patent law as well as procedural law. And but of course this needs time, and it needs the respective cases. But this is not different from any other court in this world. That the cases come, and then they are give the court the opportunity also to develop certain legal interpretation of the law, and thereby this help the users of the system in general to better understand and to have a more or have a clear idea how the law is going to be practiced also in the future.
Thank you, Judge Grabinski. I will follow up on a question regarding on the conduct of proceedings. As you mentioned, the proceedings, you have a written part and an oral part. How do you weigh the importance of the trial, hearing, and advocacy? Do you think that written proceedings have the same weight as the advocacy?
Yes, absolutely. In the UPC system, the written proceedings are very important. They set the scene. The facts have all the facts have to be in the written submissions by the parties, and they are the clear basis for the oral hearing. The judges, how do they work? Well, we have the so-called judge rapporteur. That's the judge who does the case management up to the oral hearing. And prior to the oral hearing, at least to my understanding, at least in most of the division, that's the case. The judges, after having read the written submissions, and they read the written submissions, I can assure you, they come together and pre-deliberate the case and form already a preliminary view on the case. And on that basis, then they they come to the oral hearing, and then the oral hearing is has as a main purpose to discuss the issues that at the end of the day will be the decisive one for the case. So the judges, one of the judges may, and in most cases does, give an introductory remark. So kind of focusing the debate on the issues the panel thinks are the decisive one for the case, and that then allows to discuss the issues with the parties in the oral hearing, which normally works the same way like the written submissions, that each of the parties has twice the possibility to argue their case. So like in the written procedure, it starts with a statement of claim, response, reply, rejoinder. You have the same system, at least in many divisions, that the claimant gets a slot to plead the case. Then you have the defendant to reply, and then you have another round of pleadings, and the judges they can take an active role in the hearings by asking questions to the party representatives, and possibly also to party experts in the room if needed.
Thank you. Judge Lignieres, from a local division point of view, how do you organize trial hearings? Do you discuss the case and make a decision before the trial hearing, like a preliminary opinion? Or do you want to arrive without bias before the trial hearing?
Well, at the start, before the trial hearing, the representative already know what the panel considers to be the most important legal issues for the coming decision. Because at the stage of the interim conference, we discussed with the judge rapporteur and the representatives, and it's about 3 weeks or 1 month before the oral hearing, about the main legal issues. So the hearing is very well prepared in advance. It's very well structured with a time frame, but we don't know the outcome at this stage. The judges of the panel have a pre-meeting around the day before the hearing. They discuss about the case, but the hearing, the trial hearing, can be very decisive in cases of doubt amongst the judges on certain points of law, and the answers to question, as President Grabinski, we have the habit to ask for question on specific legal issues during the hearing. And it can be the response from the lawyers can be sometimes decisive, and we can change our mind. So the trial hearing is well prepared in advance, but can be decisive.
Thank you. And we discussed this morning the possibility of obtaining an order to preserve evidence, kind of done raid. What would you need? What would a patentee need to bring to the court to obtain an order to preserve evidence, Judge Lignieres?
So to obtain an order to preserve evidence, the conditions are simple. They are the following. First, the applicant is entitled to the rights of a valid patent at the time of the filing. That means, for example, there is no opposition pending before the EPO concerning the patent in suite. Second, the applicant has sufficiently provided at this stage reasonable evidence to support that the main claims of its patent have been infringed. Third, the applicant needs in order to gather more evidence for the purpose of proving the alleged infringement. And the UPC can issue also an urgent order if there is a risk of destruction of evidence without hearing the defendant, so ex parte. And so the claimant can have the surprise effect for the defendant at the time of the saisie measures. So the standard of evidence required, as the Court of Appeal has already stated, is not very high, much lower from the PI, for example, since it is because the claimant does not have enough evidence to bring an action on the merit that they request the saisie, the inspection of the premises. So often before the start of the proceedings on the merits, and this measure allow an application, the applicant to gather evidence in support of their claim. So it's a very, very useful tool that you can use as a claimant to be sure that you have enough evidence to bring when you are coming for an infringement action on the merits.
Thank you. What is the role of experts in the proceedings? Would you consider examination and cross-examination? If so, would it be the key evidence of the trial?
Well, the proceeding before the UPC, as you have already understood, are essentially written. Each party often submits a written expert opinion, and the presence of a technical expert, it's not really, it's really rare because we have at our side in the panel, as you understood, the technical judge, who is an expert in this field. So it's really rare when we will have the necessity to appoint an expert due to the presence of this technical judge in the panel. So therefore, there is no cross-examination at the oral hearing, and this oral hearing, as President Grabinski already explained, lasts as a standard cases only 1 day.
Thank you, Judge Lignieres. Judge Grabinski, some people are pushing for the UK to join the UPC, notably due to the fact that UPC is issuing injunction covering the UK territories. What are your views on this subject?
Well, thank you. That's a bit of a political question, but thank you anyway for the question. Let me first mention that the agreement and the rules, as we find them right now, are the product of collaboration between a number of states and judges and lawyers from these states, and UK played a very prominent role in the development of these of the legal framework of the UPC. Because it all dates back to the time when before Brexit took place, and during the time UK was indeed a very important player on that level. And when you look at the agreement, the rules of procedure, you find a lot of things that you are quite familiar with when you have a common law background. And I also on a personal note, I had a lot of respect, and it was always very good to work together. I was a member of the drafting committee of the rules of procedure, to work together with a lawyer from the UK and the judge from the UK, and I learned a lot about how it works in the common law system in the UK. So it was very much to my regret that the UK, well, first, this was not to my regret. First, after the Brexit referendum, the UK at the time decided to anyway ratify the UPC agreement. So after the Brexit referendum, And so there was already at the time a discussion whether this is possible for the UK, having at the same time the target to leave the EU, but it was considered to be possible. This was the majority view, to stay in the UPC even after a Brexit. But then, a few 1-2 years later, the government changed, and the new government decided to withdraw from the ratification. But just as a side remark, the UK is still a signatory state of the UPC agreement. Having said this, at the moment, it is of course politically. It is not a topic that is discussed on the political level. Whether this is going to happen in the future, that remains to be seen. But I would think that from the European side, there is at least one condition that clearly has to be met, and that is that the UPC has to apply union law when there is union law to be applied. By the way, patent law to a large extent is not union law. It is dealt with in the UPC agreement, but not dealt with by union law. But when union law is to be applied, union law has to be applied. And if there is a question how to interpret union law that is relevant for deciding the case, which is not clear and has not been clarified by decision of the European Court of Justice, then the UPC will have to make a referral to the European Court of Justice, and that will not change. That I think is rather clear. And whether this is one day in the future acceptable to other European states, that again remains to be seen.
Thank you. And to go on political question, do you think that the entry of Ireland in the UPC is expected? And if so, would you expect it to influence the future of the court for a more common law approach with, for instance, more weight on the expert and longer trial hearing?
Yeah, well, indeed, Ireland is a member state of the European Union, and all member states of the European Union that have not yet joined the UPC are invited to join the UPC, as also, by the way, was mentioned in the Draghi report. The former president of the European Central Bank, and in order to increase the competitiveness of the European Union. So yes, Ireland, the door is open for Ireland to join, and to my understanding, the Irish government, but also positions of the Irish parties, in principle, would like to join the UPC. However, there is a requirement under the Irish Constitution that a referendum must be held. And last year, in a very different matter, a referendum failed, and one has to wait when the Irish government will see the right moment to bring this question to the Irish people, whether they support Ireland to join the UPC or not. And once Ireland is in, of course, it will be the first contracting member states that has a common law background, and that, of course, will be very interesting because I'm absolutely sure that also the other member states and judges coming from other member states, so having a continental law background, can learn a lot, and it will be an enrichment for the court if Irish judges will join the court. And what this then, at the end of the day, of course, it's a unified court, and it should not be different at different places. But there is, of course, always discretion, and there is always a bit of a local flavor, if I may say so. So it is should not be too much, but a little bit is possible. And of course, that also then would be true for a local division if this is going to happen located in Ireland.
Thank you. And as a final question, so on June 1st, 2023, UPC was launched. We are now during the period of transitional period where you have a cohabitation of the UPC and National Court for 7 years. So who will decide to renew or not to renew the transitional period? And would you already have a hint of such renewal?
Well, formally, it will be decided by the contracting member states. But of course, before there will be a report on this, there will be a discussion also with the presidium of the UPC, whether there is a need to extend the transitional period or whether the transitional period should come to an end after 7 years. That is, of course, a political decision. At the end, it's for the contracting member states to be decided. But I'm sure one criteria that, which is also, of course, was the reason why there is this transitional period with the as you said, the cohabitation between national courts and the UPC, meaning that for classical European patents that have not been opting out, the claimant can choose where to bring the case, whether in the national court or whether in the UPC. So that concept was established, was implemented in order to allow patent owners to gain confidence in the new court. And to see, does it work, does it not work? And if it will not work, if they don't have confidence, they still can use the old system. And it will be after 7 years, or possibly a bit before, to be decided whether the UPC has already reached the maturity that this is no longer needed. That it is already a stable institution with a stable case law and a reliable system, and then there is no alternative needed any longer. And well, you look at the development of the cases, decisions coming out of the court that getting more and more allowing users to get a clearer view on how the agreement and the rules are going to be applied. That at least could be an indication on how this will be decided in 7 years' time. And still, we only in year 2, so between year 2 and year 3. So we will still have some time to further develop the case law and further gain confidence from users. And then we will see what member states how they think about it, whether there is still a need after 7 years for having this parallel system, or then all the European patents, litigation about European patents can only be decided by the UPC. By the way, let me also mention those that now applied for a unitary patent, and this is about a third now of all patent of all granted patents. They already decided against a transitional period, and only for the UPC, because the unitary patent litigation concerning unitary patent can only be brought in front of the UPC.
Thank you. I know we're a bit short of time, but maybe if some people, we can take a couple of minutes if some people from the audience ask questions. John, I see. You're going to take the mic.
Thank you for the judges appearing here today, given, I guess it's their evening. So we appreciate it. It's been very informative. You talked about the technical judges that are assigned. How many overall are there? Is it, 20, 50, 100? And is it their full-time job, or is this just part of what they do?
Yeah, it's more than 70, and they are all part-time, and they come from very different backgrounds. So some of them are technically qualified judges in their countries. So, for example, Sweden, Germany, they know technically qualified judges in their national systems, and we some of our technically qualified judges come from their ranks. Meaning, for example, that the judge that comes from the German Bundespatentgericht works 90% still with the German court, but 10% with the UPC. So that is one source for technically qualified judges. Another source is our patent attorneys. So patent attorneys that are in private practice, and then of course, particularly with this group, the issue comes up about conflict of interest. And in that regard, what is always done before a judge is assigned to a case, they do a conflict of interest check, more or less what a patent attorney has to do all the time when a new client appears, knocks at the door, and asks her, "Do you want to represent me in this case?" Then the first thing the patent attorney, like any lawyer, what they have to do is to do a conflict of interest check, and the same is true for technically qualified judges. And there's another thing that should be mentioned. When you are appointed a technically qualified judge in the UPC, you cannot represent a case in the UPC. So it is not possible that on Monday you are a TQJ in a case, and then without any relation as to the parties, on Friday you are represent the case in the UPC. So that even if there is no as such a conflict of interest, this is impossible. So technically qualified judges can never represent the case in the UPC. And then the third group, where the TQJs come from, are retired. For example, members of the board, EPO boards of appeal, can also be just very few professors, different kind of retired persons, but still very much able to handle cases, so that is essentially where the technically qualified judges come from. And then, of course, yes, that I wanted to mention as well. They have essentially 5 backgrounds. So they are either have a background in mechanics, in electrics, which also covers like any kind of electronics, computer science, and so on. They can have a biotech background. They can have a pharmaceutical chemical background, or they come from physics.
Thank you. Does anyone have additional questions now? So, thank you very much for your time, your energy, and your comprehensive answers. And I hope we will see you next year, maybe, like in the next UPC day. Thank you very much, judges.
Okay, thank you. So have a nice afternoon.
Good afternoon.
Thank you.